Welcome back to Behind Enemy Lines with Terry and Mike. Thank you for being back, folks. We got an interesting guest. All our guests are interesting, but Jason Fick has a very interesting story that a lot of us will relate to. Tons of, especially me, with what's going on and have been going on. Jason's been battling Facebook for a long time. He's been in a massive battle. And one of the things that is kind of interesting, we were talking a little bit before the show started, is that Facebook and all these other social media accounts don't really like to have this guy on the air, right? So we're not going to just go naturally viral because Jason's on with a great topic, right? It's gonna affect us. So if you guys want to share it and stuff, it'll be very helpful. But he's gonna share his experiences with Facebook, why he got into this battle with Facebook, why he actually got it all the way to the Supreme Court a few times. And unfortunately, he was rejected, but he's going to tell you about that and why he's going to continue this battle. So it's not just for him, it's for all of us, especially us on the right. So I'm excited about it. So before we throw it over to Jason, and I'll let Jason, you could do your own little bio and stuff, and then let you just ramble from there, and me and Mike will jump in. I want Mike to chime in, my podcast wife, and then go from there.
Yeah, and real quick to the audience, yeah, if there was a time that we needed you to share this so we could actually reach people, it's tonight. Facebook hates Jason, not to mention a lot of the other social media companies fear what he's working on, because they'd be real reforms or elimination, really, of Section 230. Now, I know some of you guys have probably heard that term. Jason will be able to kind of give you a detail on what it is and why this law has been a problem since the very beginning, and more importantly, what the real solutions are. So with that, Jason, take it away.
Hey, Mike, Terry, thank you guys for having me on. I appreciate it. Let's talk about. I saw at the very beginning of this the white whale, and I mean, I do start to feel like Captain Ahab here with my white whale, because I am trying to take down an absolute monster. And that's
The
really why they don't
Leviathan.
like me. Yeah, this thing's a beast, and the thing it's strange. So let's go back. Right, let's rewind the clock a bit. Right, This was 2010. I got onto Facebook and I started using it, and I started building an audience. Right, and I caught on. This is before the there was no politics on there. It was mainly kids. It was like it was young.
Yeah.
Right, it was all just fun, stupid stuff or whatever else like that. So I started building this audience, knowing, right, because all of us know that distribution's key, right, in everything. Advertise, distribute, whatever you do, you need to be able to, like, at the time I was writing a book, and I needed people to read it. So I just started building these audiences, although I didn't quite realize the magnitude of what I was building, right? Next thing I know, and I remember the days when I was like 10,000 fans. Holy cow, man, you're like well known, right? And then like the people that were huge, like, she's got 60,000 fans, right?
Yeah.
Do you know at my peak I hit 38 million?
Wow.
Huge.
I could change national trends. Like, legitimately, I could start posting about stuff, and it would change the way the media responded. And I did it. I mean, we're not going to go into that story today, but like, I'll give you a good story. And how this really was kind of my breakout moment as to how I understand, how I did this, because one of the biggest problems that everybody faces with all of big tech is monetization, right?
Yeah.
And it's a war of attrition, right? They know that if you say the wrong thing, they are going to shut down your ability to make money, and that is either by cutting off your ability to reach your audience, right?
Yep.
What you worked hard to establish under their promises and public representations, right? Yeah, it's a free platform for all ideas, unless it's an idea we don't like, and then we're not really going to make it free. We're going to take that crap away from you.
Exactly.
That's really what they do.
You know what's funny is about a year ago, I hit around 3,100 on YouTube, and I did a few things they didn't like, stories. I had Dr. Robert Malone on and stuff like that.
Oh yeah,
I maybe grew like 300 people in a year.
Yeah.
In a year.
It's because they just don't show you. See, here comes the problem.
Yeah.
The algorithms are ultimately designed by someone. That someone has a bias. And the problem that we come into is they come into courts and into the court, and they go, "Hey, we were acting in good faith. They violated our community standards," and out the cases go.
Yeah.
Right. And I kind of pivoted But let's actually talk about what that really is. So the question is, why are they leaving the courts? Because there are actually paid trolls that try to confuse people. If you say
Oh my
Section
God, that's
230,
what
they
I
will
think
be
happened to me.
yeah, they will be all over you, and they are paid by these companies or AI, one or the other. I don't know exactly which yet,
Probably both.
but they do it to confuse people because they're always arguing, oh, so you don't want them to have First Amendment rights, these big tech companies. Well, let me dispel that real quick.
Mm-hmm.
They have a First Amendment right to leave up anything they want or take down anything they want. That doesn't violate your rights. If they take down your content, guess what? That's not a violation of rights. Now, everybody thinks that. They go, my free speech rights were infringed upon. No, that's not the case.
Right.
The government has to be involved in it to be a free speech infringement, meaning for rights to be actually be denied, it has to be government.
Correct.
But
yes.
see, there's this crazy thing called Section 230 where the courts themselves provide what is called an affirmative defense. Kind of a scary word for some people, but it's really not. The simplest affirmative defense that you know of is what?
Well, so
right?
before you say that, Jason, could you please explain to the audience what Section 30, from 1996 or explain what it is and why it initially got started and then go from there.
Okay. So Section 230 was, there's this case and a company got held responsible for what somebody else posted on their site because that company represented that it was a family friendly site and they got held accountable for what somebody else did. That's not right. If somebody else posts something and the site's not aware of it, they shouldn't be held accountable for it, right?
Mm-hmm.
So what's the easiest way to prevent you from being held accountable for what somebody else does? Is you say in a law, which is Section 230 of the Communications Decency Act, right? It was written in 96. In the law, it says you cannot treat the provider or user as, and I'm just summarizing here because courts aren't applying it like this.
Yeah.
You can't treat them as someone else.
Yeah.
That's real simple, right? You
makes
can't
sense.
treat them as somebody else, some other publisher, some other content provider. If somebody else posts up on there, they're not responsible. Now, that doesn't mean that they're not responsible for their own actions. It just means that they're not responsible for what somebody else did.
Yeah.
That was the first piece of the law. That's what they call 230C1. That's the 26 words that invented the internet. It didn't invent the internet, and it's more than 26 words, first off.
And I think when it was initiated, too, they wanted to establish the opportunity for fast growth and the dot-com bust and all craze and all those things. That's what was the intent back then.
Precisely. It literally states in it that it was to protect free speech and to proliferate business, not crush it.
And again, we're talking early stages of the internet. You're dealing with a bunch of octogenarians in Congress that don't understand the internet, much less know what it is. And they're regulating like it was almost like it was another public utility or a public forum without the understanding of all the ramifications, especially when now we're 30 years later almost. And we're seeing the effects of that really beginning 20 years ago.
Let me slow you down because I know you're going down a road that is one of those roads that's like, no. Let me ask you something. Is the Constitution outdated? Do you believe that?
No.
Why?
Well, because it's still applicable to today. Well, I don't necessarily think that 230 is outdated. I think they didn't understand what they were doing when it was written. I think they had a poor understanding of what they were trying to regulate.
Well, that's what I'm trying to get to here is, and I'm going to change your mind on this. This is real simple. The Constitution is a great example of it. They understood what they were up against. Now, they may not have understood necessarily firearms and the advancements of firearms and so forth.
Sure.
But the Second Amendment's pretty clear. It shall not be infringed. It's real simple, right?
Mm-hmm.
Yeah.
Well, that's what Section 230 really is. It's simple. It prevents them from being treated as another entity. That's the first portion. And then the second half says that they're allowed to take down certain content, right? Lewd, lascivious, excessively violent, harassing, or otherwise objectionable. And everybody says that's the problem. That's why. Otherwise objectionable. It's too broad.
Yeah.
Right?
Yep.
Well, no, it's actually really simple. Let me go back to what I was saying about an affirmative defense, because this is all going to make a whole lot of sense real quick, right?
Sure.
Self-defense is the easiest affirmative defense to understand, right?
Yeah.
in self-defense, what is the basic principle of it? Real basic.
Your life's in danger. You're in danger.
Yeah, bodily harm or your life's in danger. Yeah.
Okay, so it is the protection of self or the protection of others. You can commit an otherwise unlawful act, homicide, right?
Yeah.
It's illegal otherwise,
Mhm.
but if you commit homicide in the prevention of future potential harm, it hasn't even happened yet, the future potential harm, right?
Yes.
It's what's called a prior restraint. It means that you can restrain somebody's rights, right, under government authority,
Mm-hmm.
right, the affirmative defense, if and only if. Now, let me ask you something. If you shoot somebody and you say, I shot him in self-defense, do you get to just roll home?
No, you
Probably
gotta
not.
put a gun in his
No.
hand and then call the cop.
Yeah, and sprinkle crack on him.
I know we're being facetious here, but
Yeah.
at the same time, you go, no, you can't. You're going to get arrested. You're going to go in. And what are you going to have to do? You are going to prove in a court of law that your life was in danger or that you at least felt it.
Yeah, there's
And
a
who is
reasonable
gonna make-
expectation.
Correct. There was a reasonable expectation. So, and then who's going to decide whether or not that was a reasonable expectation?
Usually
The
a
court.
jury, sometimes a prosecutor.
Okay. Well,
No,
prosecutor's not. The judge might. It might be a bench trial, but
people,
it's generally a jury, right? A jury of your peers.
Yeah.
Well, that is exactly how Section 230 is supposed to function. Everybody says, well, they can do whatever they want. No, they actually can't. The thing is that the first part keeps them from being treated as someone else for somebody else's conduct. The second half of this thing says, well, they can take it down in good faith. But who decides good
Who
faith?
decides good faith? There you go.
Not the judge,
Yeah.
not them, a jury of their peers.
And they forgot
Yes.
to do that part.
That's the part they didn't forget. They skip it. And this is where the mistake in Section 230 lies that everybody has overlooked. And I'm going to explain exactly how it happened, exactly why it happened. And the reality is your California courts are doing it deliberately.
Mhm.
They will
Oh, yeah.
not fix this. And I'm going to so let's get into why it broke. Why the internet is busted. One word. It literally is one word. It comes down to one word. I figured it out, had an epiphany one night, and I realized I knew what they did wrong.
Hmm.
So that first part that says they can't be treated as the publisher or speaker of any information provided by another information content provider.
Mhm.
In the English language, that means that one party can't be treated as another party. That's what it's supposed to mean.
Yeah.
That is not how the courts have read it. They read it as no provider or user of an interactive computer service shall be treated as a publisher of any information provided by another information content provider. They changed a definite article to an indefinite article, and it changes from they can't be treated as someone else to they can't be treated as a publisher. Changes from a who to a what.
Yeah.
All of a sudden, they cannot be held accountable as a publisher when they become a secondary publisher when they engage in publishing conduct. Guess what that does? Well, all of a sudden, they can't be held accountable as a publisher. You ever hear that?
Yeah.
Like
They have de
conflict of,
facto
are they a
immunity.
publisher or they a
Yep.
platform? No. They are a platform acting as a publisher who can't be treated as a publisher, and therefore you never have to get to the second piece of the law, which says that they actually have to act in good faith, so it
Mhm.
never goes to trial.
Mhm.
That's how they beat the system. And the thing is, and this is what drives me nuts, is the petition that we gave the Supreme Court. We just gave it. We handed them the solution to the internet. Here it is.
Yeah.
Affirm one sentence that 230C1 does not protect any first party affirmative conduct at all. It doesn't protect their own publishing. That's it. It's over at that point. The whole thing, because now all of a sudden what happens is, and think about the ramifications of this, right? Everything starts to resolve itself downstream. And that is why they are terrified of what we know and terrified of fixing this, because this takes the power out of the corporate hands, right? It destroys the bureaucracy. Why? Because no, the courts cannot compel them to host speech. They can still take it down. But now they'd actually have the accountability that if they take it down, we're no longer barred from court. That's what happened to me. I was literally never allowed into the courts. They said I could not treat them as a publisher. Done. Well, what about the good faith thing, right? We all know it exists. That it never applied to my case. If I'm allowed into the courts, all of a sudden liability is going to change their behavior, isn't it? They're going to stop doing this shit. And then all of a sudden, if they stop doing that, they can't act on behalf of the government automatically because that'll be bad faith. Right?
Yeah.
We just fixed the internet. Like, that's all it took. And we handed it to the Supreme Court. It's mind-boggling that they didn't take this. I mean, we even had 3 major amicus briefs at the cert stage, which never happens, right? Major names. We were just talking about General Michael Flynn. He was one of the ones that stepped immediately up. Ann Vandersteel, Maureen Steele, you know, everybody from Roger Stone, Silk, you know, everybody was signing on to this thing. We had like 50 major names signed on, and it was like, Supreme Court, this isn't about me.
Well, yeah.
This is millions of Americans. And didn't it just happen to you, Terry? The same exact thing.
Yeah. Yeah. And they don't even tell you what you did wrong. They just say, and you know, to our buddy,
they don't have to justify it.
Yeah, because you know our mutual buddy Ryan Hartwig, with you know, they hire their fact checkers from Cognizant, by the way, with one of my competitors.
Yeah,
they were one of my direct competitors. My last job for 20 years.
Were they?
Yeah. So Cognizant is hired by Facebook to be the fact checkers. Obviously, they're going to follow the rules and guidance laid down upon them from Facebook. Right. Well, they want to keep their jobs. They want to keep billing. They want to put more people in there. So that's bullshit. I think I don't need to tell anyone that. It's all bullshit. The fact checkers were bullshit.
Notice how Facebook actually stopped the fact checking?
Yeah.
I think that was directly
because of Trump.
No. Here's the problem with fact checking. And this is something that the courts are now no longer overlooking. See, because so the other thing about what we're talking about here is the Ninth Circuit, which handles 90% of the cases, is the one that's deliberately getting it wrong. Other circuits, the 3rd, 4th, and 5th, are in agreement with what we say. We're right. Like, we're 100% right. We're backed by major circuit court decisions. Those courts have recognized. So the thing is that the role shift, right? When they stop being a platform and they become what's called an information content provider, it means that they're engaged in content manipulation. It says that if they have any involvement in the creation or development of information provided online, the courts overlook the term development as if it involved creation. It doesn't. Development is purely manipulation. So all fact checking bridges them both, because all they're doing is they're paying a third party to launder content creation, and the whole time they're developing it. They're deciding what is and is not right and what can be advanced, what prioritized. Well, guess what? Third Circuit figured it out. Third Circuit in Anderson versus TikTok, spot on, right? And this will make a really good, easy way to understand this. Basically, what happened is somebody died because of the blackout challenge. Remember that kids were doing it?
Yeah.
And it was shameful, right, that it was on there. And the thing is that Anderson sued TikTok. TikTok brought a 230C1 defense and said, we're not the publisher speaker of that content. Well, that court was a lot more careful, a lot more honest than the Ninth Circuit. And they said, wait a second. They're not trying to hold you accountable for the challenge itself. We're not trying to treat you as the one who created that content. We're holding you accountable for the recommendations of your algorithm.
Yeah.
They realize that 230C1 doesn't touch their own conduct. That's their own negligence. And that right there is the resolution to the entire thing, is that no, what they're doing with fact checking, with what they're doing with the manipulation, allowing or prioritizing or boosting, all of that is subject to liability if they resolve this. So the magnitude, that's why they won't do it. This changes everything.
So Jason, what now that they got rid of Cognizant and who's doing their fact checking at Facebook? I don't know if you know the answer to that.
I don't even know. Are they doing fact checking?
I don't think they are.
I thought he ended that.
Well, because
that's content creation and development. Straight up, they are responsible for all of it.
Well, yeah, and I don't remember if this was just before or just after the election. They actually brought on, I think it was before the election, a couple of conservative organizations to also assist in fact checking. And then, of course, they had a bunch of people melt down there. And then Zuckerberg came out, I think, just after the election, said we're ending our fact checking program, because also one of them didn't. One of their fact checkers got sued and lost, didn't they? I'm pretty sure it was Facebook. And
As they should. It's their own created content.
yeah, well, I'm pretty sure it was the fact checker directly that was sued and lost, and then they decided hands off because I'm sure they sensed blowback. But yeah, to me, this clearly sounds like the Supreme Court didn't want to take a stance in this, did not want to weigh in, and I'm sure that was due to pressure from a lot of these big social media companies, because you know the endless frustration. This is, again, we were talking about this off air, is like with YouTube or Facebook, like X American News. The reason we're not on YouTube consistently is because we keep getting strikes and we never know what they're for. They won't tell us what the rules are. Same with Facebook. You know, it's a black box. Whereas X, Rumble, Getter, Kick, all the other places that we stream, we know what to expect. We know, you know, if there's a lot of foul language in a program, it's not going to get promoted as much. There are certain topics we know that don't do as well on different networks, but we know what the rules are. So we can abide by those. If that means occasionally we've got to tweak something we're going to do, that's fine. We get to choose to, or we get to choose not to put up on the platform. And then we don't have to worry about strikes or other blowback for putting the content up, which doesn't just harm one program on our network, it harms everybody. If they were just open about the rules, we wouldn't have to deal with that.
So, Mike, was that a subtle dig to me to stop swearing?
Ha, no. But I do know that, like, if you, like, for example, and I don't know if they're all like this or not, but I know with, or I'm told, I should say, with YouTube, if you have F-bombs within the first 3 minutes, they won't recommend it to younger subscribers, that it won't show up in people's feeds. Now, again, if they were more honest.
Reasonable, though.
Exactly.
But that's reasonable.
Well, I would tend to agree. If the platform once those rules, if they're telling us that's what they are, I would say that is reasonable. The problem is I have with those are it's a black box. We don't really know what the rules are, and they won't really tell us. I mean, they'll give you generalities, like, you know, obviously, like, you can't have a live execution on there, but, you know, otherwise we never know what they're going to issue strikes for until after the fact. And even then, a lot of times they won't tell us what actually did it. They'll say, oh, it's medical misinformation. Well, we have no idea, and we don't have any idea what program it was assigned to, just that it happened sometime yesterday. And it's just infuriating when you're trying to build up a network or build up a program.
But yeah, we're gonna do a little test after this show. I'm gonna push this show out on LinkedIn. I got for LinkedIn, I got like 8,000 followers, and we'll put this out there and we'll see what happens. Like, I had a post a few weeks ago, got like over 500,000 views and stuff. So I'll cure. This is not a political show, right? This is a factually based show on some of the things Jason's doing around Section 230. So we'll see what happens, and I don't know. We'll see.
Yeah, I mean, this whole thing, being that it's fixable, is what drives me nuts. Is that it's really not that hard. The courts know, because not only is it the Third, Fourth, and Fifth Circuits, opposing the Ninth Circuit, Ninth Circuit law opposes the Ninth Circuit. They literally, in my case, right, they applied 230C1, the whole I can't treat them as a publisher thing. They applied that as an immunity from suit, meaning there was no factual basis, there was no discovery, nothing, not a single hearing, right? So that is immunity from suit. That is a denial of all merits. They just didn't adjudicate it, right? They said, get out.
Mm-hmm. Yeah.
The funny thing is they cite to a precedent called Barnes versus Yahoo, right?
Mm-hmm.
To apply 230C1 as an immunity from suit. Do you know that it actually says in Barnes versus Yahoo that immunity is nowhere in Section 230, that it doesn't actually provide any immunity at all? So the precedent that they cited to apply it as immunity says it's not an immunity. And it's like, what is going on with this court? Like, they won't even apply their own precedent lawfully. Yeah. And it's because I think what they know. So my case against Facebook is worth a fortune. Like,
oh, I'm sure.
Stupid money. Why? Because we were talking about it offline. At my peak, I had 38 million fans. Right,
That's
I
crazy,
can
brother.
document 25 million of them. Right.
Yeah.
And this was in 2012 to 13. I was
Wow.
making $300,000 a month then.
Oh my
Yeah.
God.
Imagine if they hadn't put their hands in it and left me the hell alone, what I could have done with it.
Yeah.
Billions of dollars. It's what's called a prospective economic advantage. I was already so far ahead. I was bigger than BuzzFeed. Like,
Really?
cumulatively.
Yeah.
Yeah.
And that became a multi-billion-dollar company until, of course, big tech hammered them.
Yeah.
But that's just it. Is that it's unfair competition and anti-competitive behavior as a business model.
Mhm.
Their whole business model is, I'm going to take money from one user to
Mhm.
displace you as another user, and then I'm going to claim ambiguous terms of services that you violated, and say, well, you violated one or all of them from this link, and then I'm going to claim that I can't be treated as a publisher, even though I'm acting as a content developer.
Yeah.
It's a perfect scheme. And the worst
Yeah.
part is, this is the craziest part. So when I brought my suit in 2018, right, I knew that the government was kind of involved. I
Yeah.
had no idea it was involved to the extent that it was involved. Now
Oh, I'm
think
sure.
about this. All right. This is where the pivot of what I'm dealing with right now is. I've come to realize that in 3 trips to the Supreme Court over the past 7 years of litigation and not getting a single hearing, with case law actually matching what happened to me in the Ninth Circuit, as well as the multi-circuit split and them ignoring it every which way.
Yeah.
I had a judge with millions in tech stock. I had another one threaten my attorney. I've had stuff that was not ethical coming out of this court. And I think a lot of the clerks are actually some of these trolls that are online. And they have deliberately blocked this. What they don't realize is that there's something called a 60D3 rule.
Yeah.
Now, ready for this? First time I've ever even said, because everybody says, well, what are you going to do now? Right? 3 petitions to the Supreme Court. I'm out of remedy. There's nothing left. The United States has now denied me of my constitutional due process rights. I was
Yes.
entitled to my day in court and I didn't get it. Right?
Mhm.
So what do? Well, 60D3 is what's called fraud on the courts. The government has been clearly involved with Facebook, and Facebook has admitted it, and the government has admitted it, which
Yes.
means that there is a corrupt fraud that is going on, and I believe it extends to the Ninth Circuit, to the California courts. I believe they're involved in it. I believe that they were. So what happened is the way the censorship industrial complex basically came about is because the Ninth Circuit could protect them from all antitrust liability if they chose, but also leverage it and say, we'll expose you to it. We'll remember Biden up there and, we'll take a look at Section 230. Yeah, that was the carrot and stick approach.
Yeah.
Because it was able to be used both ways as an immunity from suit and also as actual antitrust exposure.
Yeah.
They could control them, and they don't want to resolve that ambiguity. But I think that California courts are involved, but guess what this allows me to do? Move jurisdictions.
Oh,
get the
that's
hell out of
that's
California.
brilliant.
Yep. It's something called a collateral. So what I'm going to be doing is under Rule 60D3, I'm going to be bringing what's called a collateral attack, meaning I am no longer just going to sue Facebook. I am going to sue the United States of America for fraud and for its involvement in denying me of my rights, because I couldn't have sued the United States. Remember, I said that it's not a violation of your rights when Facebook takes your content down, right?
Yeah.
Mhm.
It's not until the government immunizes it, meaning if they deny you of remedy, now my rights
Well,
have actually been violated, which means then I can go after the government itself. And guess what else it's going to be? You're going to like this word. Constitutional challenge.
yes.
I am actually going to be suing the United States, seeking declaratory relief that Section 230C1 as applied is unconstitutional. The court's actually going to have to deal with that one finally.
So
They're not going to be able to sidestep it.
This strategy sounds interesting, right? But who's going to make the decision to allow you to do what you just told us?
It's not a decision that they can allow. It's a decision. I can bring my claim. See, I'm going to be bringing it in under. Well, I'm not going to say where exactly.
Yeah, I was going to say you might want to keep that to yourself.
But I'm going to be bringing it in a court under the Third Circuit's jurisdiction. The Third
Well-
Circuit has already figured this out. So when I'm walking into the court, I'm saying that I was
wait,
denied.
Sorry to interrupt you. Explain that. So, all right. So the ninth district was where the challenge is, and I think we all agree that's in California with all the leftists.
That's where my case was against
Yeah,
fake
all the
news.
wacky
Yeah,
Yes.
the Ninth Circus, as they used to call it.
Yeah, what you're saying is you're not going to go there. You're going to go somewhere else and declare why you need it somewhere else instead of the Ninth Circuit, and you're going to explain your case based on what you just told us to this other court outside of whack job California to say,
Yep.
hey, this is what I think's happening. Do you guys agree? And can we do this here?
Okay.
Did I summarize it
so,
right?
Yeah.
or-
So let me explain this a little better. So everybody's going to say, all the attorneys out there are going to say, "Oh, he's out of his mind. You can't bring a case twice." Well, here's the thing, guys. Remember what I said? It was an immunity from suit.
Yeah.
They never actually got to the factual analysis of my case, right? They never got to the merits.
Yeah.
Means that I'm not actually bringing my suit twice.
Twice.
I'm bringing it for the first time ever.
Yeah,
I was
'Cause they never-
barred from the court.
Mm-hmm.
yeah, that's
You got it
brilliant.
now?
Well, I don't know how applicable this would be to your case, but again, one of the things that was exposed through the Twitter files, and I think you could make a reasonable assumption the same thing was going on at Facebook. The federal government is not allowed to violate your constitutional rights through a third party either, and that's one of the things that was brought up over and over again with the pressure they're putting on Twitter to censor people, pull them off the platform, and take a number of other actions that they took. So you can make a logical assumption that this is part of what went on with your case. Is again the federal government, in an effort to protect their own self-interest, protect what was going on with Facebook and the special relationship that they had, that they may have also stepped on your rights, which is unconstitutional since they did it through a third party.
So you're saying through Twitter, Facebook admitted it. Zuckerberg admitted that the government was involved with it. So,
Yeah.
so you have to understand. Everybody says, well, they weren't coercing them; they were just making doesn't matter. It's what's called pervasive entwinement and joint participation. That's it.
Mhm.
That's all it is. The qualifier is for constitutional deprivation. The thing about that is that when Trump took office, right, he put the DOJ to work and he wrote executive order. I think it's like 14148 or something like that about fixing the internet. Well, what that did was it tasked the DOJ with getting a report from these big tech companies, which is due in like a month or two or something like that. The DOJ is involved in other cases, and it will be involved in this case. The constitutional challenge means I'm suing the United States seeking declaratory relief that a law is unconstitutional, right?
Yeah.
Either as applied or on its face. So I'm physically going after the law now and the government who denied me of my rights. But see, the thing is that I know, because I'm involved back end on some other big cases, the DOJ is already positioning itself saying, and I mean, I'm not kidding you, and this is not something that's out there. The DOJ is basically preparing to fall on the sword. They're saying, yep, we did this. We need to stay all the proceedings until we get the actual report so that we can hand it over to you. So we can we'll go, yep, it's our fault. Get declaratory relief and an injunction. And oh, by the way, big tech, well, now you're on the hook financially for all of your involvement with the government. So sad. Sorry. Bye-bye. I mean, that's literally what we're looking at soon. And I can tell you from a first-party perspective of somebody who has read the emails, this is happening in the back end, that the government, that Trump's DOJ is actually working on this problem. And again, like I said, is if I come in and I come after the United States as the defendant, along with Facebook in a collateral attack on a constitutional challenge, the government actually has to defend its position of the law. I already have the DOJ admitting that the law is applied incorrectly.
Yeah.
They're judicially stopped from even making that argument anymore. Plus, they wouldn't do that because they're already trying to. So again, it might be a situation where the government's going to go, "Yep, he's right. That's the way it actually is supposed to be applied, and we no longer need the Supreme Court." This is the rare scenario where a district court judge can actually enjoin a circuit level judge.
So, Jason, do you think if the Biden administration was in play now, would the DOJ be considering what you're thinking they're
No.
considering right now?
They already
No chance in
did
hell.
it once.
Yeah.
We actually did it. I brought a constitutional challenge in Washington, D.C., straight up against the government. And first off, I had the same judge that went after General Flynn, right? This guy, Rudy Contreras. What a schmuck. Anyhow, in that circumstance, basically, I think about this. The defendant is the United States of America. The defendant has just denied me of all remedy. This was the second first or second trip through the United States Supreme Court, right? I've been denied all remedy, and I'm now challenging the law. Who am I suing? The government. Why am I suing them? Because they denied me of rights. This judge denied it on standing, claiming that I was suing the United States for what Facebook did to me. And it's like, hey, moron, all you have to do is read the caption. Fick versus Facebook was about what Facebook did. Fick versus the United States in a constitutional challenge is about the United States.
Yeah.
But they do it deliberately. This is where the California courts and the Washington, D.C. courts are no better than California. I mean, they're one and the same, monster.
Essentially.
So, so ultimately in that circumstance, the DOJ actually, so what happened was we brought another constitutional challenge. I've literally tried to go after this law forever. We brought another constitutional challenge in the case itself, which is another way to do it. And then under Procedural Rule 5.1, because the United States is not a party to Fick versus Facebook, we have to notify the DOJ, which of course was the Biden DOJ. It was Merrick Garland. The DOJ comes in and goes, I don't see anything. It was like, what? These morons come in and go, like, they literally played this like sort of like circular argument, and then out they went. And then the irony is, then that judge, Judge Gilliam, another crappy judge, right, who just recused himself in another case that is a United States big tech case. He voluntarily recused him. Why didn't you recuse yourself in my case? Right? I mean, there's all sorts of dirty shit going on here.
Yeah.
Oh,
So
constantly.
Get this. He terminated it, based on it being, quote, freestanding. What does freestanding mean?
What does freestanding mean?
Okay. Freestanding means literally standing alone, all by itself. It's independent. It's separate, right? Do you know that the requirement of a Procedural Rule 5.1 constitutional challenge is that it comes as a separate and independent action? He literally terminated it for what it was supposed to be procedurally.
Yeah. So he terminated it for not being freestanding because it was freestanding.
He terminated it for being separate and independent when it had to be separate and independent.
Makes perfect sense.
It's the most circular argument. And that is what these courts are doing. They're using the statutory procedure rules to just say no.
Oh, yeah.
Like, you come to if you came to them with a case that said left, they would say, no, it's right. And I would say, no, it says left. And then the next time around, I go, this case over here says it's left too. And then they say, oh, that's irrelevant.
Yeah, right.
Yeah.
Or, oh, wait, you didn't advance that timely enough. I mean, all procedural bullshit.
Yeah,
Right?
well, and again, a lot of us are familiar with this already between all the inaction on election fraud and numerous other cases that have been brought that rather than hear the case, they'll find excuses to dismiss it on standing or on using procedural maneuvers to kick it down to another court or just not handle it. And again, this gets back to the process is part of the punishment. Again, it's like designed to dishearten you, to get you to stop fighting and just accept that they don't want to hear this case. They don't want any results, or they're perfectly happy with the way things are now, so they certainly wouldn't let you get involved to mess up whatever grift they have going on.
Hey, Mike, do you want to do your little 1 minute commercial break? Right now?
Yeah, we can run a quick commercial.
Yeah, and when we come back, I like to share, because you're sacrificing a lot of time, effort, and money. I'd like to hear a little bit about that. Let the people know. This has got to be consuming your life for years now, right? And how you're getting along.
It's horrible.
Yeah,
it is
talk about that after we get back.
Biggest grind ever.
So go ahead, Mike. Do your little commercial.
All right,
massive show.
Stay with us, and we'll be right back.
Life can be pretty unpredictable. The Jace case lets you be better prepared for whatever comes your way. It contains antibiotics and other prescription medications so that you aren't caught unprepared. Go to jace.com now and get your own Jace case.
The best way to support all the work Terry does here at Behind Enemy Lines and support all the other programs here on Ex American News by supporting our sponsors. I do want to encourage you guys to go to jace.com or jacemedical.com. Use code BEL1776, BEL1776 at jace.com or jacemedical.com. Pick yourself up a Jace case. I think I got mine right over here. This isn't a boo-boo kit. It's not a Band-Aid bag. It's not the little Johnson & Johnson kit you get at Walmart for $20. This has real medication that you need, especially during the time of an emergency when help isn't coming, isn't on the way. It contains a variety of antibiotics, non-narcotic pain relievers, steroids, other drugs that could be necessary or even life-saving if help isn't on the way. I mean, it doesn't matter if we're talking after some kind of a natural disaster, earthquake, hurricane, alien invasion, whether that's coming up the border from Mexico or from outer space. Any time where this is something that's better to have it and not need it than need it and not have it, to protect you and to protect your family. It's inexpensive, and you'll get an additional discount if you use code BEL1776 at jace.com or jacemedical.com.
Yeah, so I used to think preppers were whack jobs. I used to think the deep state was bullshit. Oh my God. I mean, since I started getting involved in this in only like 4 years, I was wrong. So you never know when you might need something like that. So Jason, why don't you share? People have to understand and appreciate, right? I do this only 2 days a week. This is very much time consuming, right? I've got a couple little cases going on myself of leftist Democrats coming after me, and explain how time consuming this has, and how do you, over the last number of years, how are you balancing like a career or income and fighting for trying to do the right thing for all of us with the Supreme Court?
No, it's not a great balancing job. Like, I mean, it's like,
trust me, I know the feeling.
Juggling, but I drop balls here and there, and it's like one of those. I'm down to like the 2, just going up and down. And it's like, all right, yeah. In terms of time consuming, it's all consuming. I'm already working on this collateral attack constitutional challenge, and I mean, I have worked on it now for basically almost every single day since the Supreme Court denied cert. It'll take me probably 2 to 3 months to write the whole thing. I'm already at 180 pages. Now it's double spaced, but that's still a 90-page document in anybody's terms. There's a lot of law and so forth. That's why, although I don't have a bar license, I can keep up with most attorneys at this point because I've just, out of necessity, I had to take the workload off of my attorneys because they couldn't do it all. But I've gotten so proficient in this is that I could basically, I wrote 85% of my cert petition, give or take. And then what happens is that most of it's done. I handed it to the attorneys, and then they clean up all of the last bits and pieces that I don't necessarily know because I don't have a bar license. And that's time consuming. But the reality of it is that how do you win a war?
Yeah.
You have to commit fully. And the way that I look at it, the name of your show is really a good representation of this. Now, I am by no means military, and I don't,
neither am I.
In any way. Okay. So, but my point is this: I respect the military, but what does the military do? The military goes in there and risks their lives. I'm risking my finances. I'm risking potentially my life. Piss them off enough, they can come after you. Mm-hmm. But at the end of the day, it's one of those. The difference is that they're commissioned into service, whereas mine's voluntary. Yeah. I'm doing something because I know that this is bigger than me. I know that this is incredibly important to the country, and you choose to serve your country, right?
Yeah.
Congressmen, senators, all that, they end up getting bought off. I am legit serving my country, and I may not succeed. I may die on the battlefield. Mm-hmm. I've been shot up so many times with all these Supreme Court certs and so forth. And to give people an idea, setting all of the legal costs aside, all of the attorneys, all of the filing, whatever, in the United States Supreme Court, in order to file in the United States Supreme Court, you actually have to print a book. All your filings have to be physically printed by a publishing company in a book form, and then they give out whatever it is, 100 or 400 copies or something like that. This last go round was 3 books and cost $27,000 to produce.
Holy.
That is a straight hard cost that I have to pay. And this is my 3rd Supreme Court petition. The reality is it's stupid expensive.
Yeah.
It is a service to my country that I have taken upon myself and chosen to do. But the thing is, why do we do it?
Yeah.
You know, why are you sitting here on the podcast? Is it for the money?
Yeah, no.
No.
You know,
I wish.
I mean, I could go make more money elsewhere doing anything else.
As a
with
matter of
this,
fact,
but
it's a distraction, not just the cost to do this, but the distraction on my life, my family, my
Yeah.
job. It is
Yeah.
a big distraction. And I had General Michael Flynn on this show, and Mike and I were on his platform for a while on our shows. And I had other military guys, and my partner was in the military. My old producer was in the military. And and these guys agree, you know, they put their lives at risk, right? Going to fight overseas or, you know, combat vet. And we're in the most important fight of in the history of America right now.
Yeah.
Right. It's an enemy from within. It's, you know, there's so many different.
Uh-oh. Terry, I think you froze. Up, you're back. Nope.
Hello,
You're gone
am I
again.
there?
You're
Hey.
back. You're back for real this time.
Yeah. It's you know, 5th generation warfare, and we're in the most important fight of our lifetime. Are we putting our lives at risk? No, we're putting our income, like you said, our families, our reputation. I was put on a terrorist watch list for speaking out against porn or peacefully being at January 6th. I didn't do anything wrong.
No.
You know, so like, we're in a war. We're in the most important war of our history of our country, even though it's not shooting bullets. And so, you know, what you're doing is a part of that war that we're trying to fight to save our country.
Yeah, it's the less violent 1776. We are square in the middle of a revolutionary war. We're trying to get, and a lot of this is foreign governments. The UK is at the bottom of a lot of stuff that I'm coming up with.
Really?
Oh, I'm sure.
The reality is I mean, think about the British accreditation, you know, registry, the bar. You know, that's all British. That's the statutory system. They have basically never let us go. They just let us pretend that we were free. And, you know, when you start getting into understanding the real constitutional law and constitutional rights, you realize that this isn't a tolerable situation. Like, no, you're not going. I mean, that's one of the other things I'm just pissed off about. Like, the government is denying me of my due process. They're actually violating my rights outright. And we're not talking about like, oh, well, no, this is truly a violation of rights. I was denied all remedy for a legal right. And yet the Supreme Court didn't step up. And not only was it my deprivation of rights that was a problem, they're doing it to millions of people.
Yeah.
Correct.
And I handed them the answer. And it's one of those, that's an embarrassment. Oh, wait. Do you know what they did take? They took one case, right? They denied mine. They denied a whole bunch of others, habeas corpus, whatever else like that. Do you know what case they did take? It's really, really, really important.
No, what?
They needed to decide whether or not Rastafarians could keep their dreadlocks in prison.
Oh, they took that case over years, is what you're saying. Yeah.
Well, now I totally understand.
It's at the point of insulting. It's just, it's like,
I guess I could bet the outcome on that. They're going to say yes.
Yeah.
You know what it is? It's the whole feel good case. Oh, it's about racial rights and stuff like that.
They're all going to agree on it, right? They're all going to agree on it. Watch.
Yeah.
Most of them, watch. They will.
But it's insulting because it didn't just affect me. It affected everybody. It literally affected more people than any other case that was even considered at that point.
Well, at the very least, your case affects just about everybody here in America, and what our interactions on social media will look like in the future going forward. It's much more important to the daily lives, to commerce, and to our Constitution than Rastafarian dreadlocks. But everybody already knows that. That's why. You know, there's millions of people that have been abused by this, but it just takes one person, somebody like you, that actually has the courage and the wherewithal to stand and fight, even though you're getting slapped in the face by our own government and their refusal to actually move forward with this instead of protect their allies. That, because again, everybody knows Facebook, they want the power. They're already tapped into it. They're already working with them, but they also want the revenue. They want the money that's associated with that. And something like this, a big change, well, that could open them up to lawsuits. That could hurt their tax base. That could hurt their investments, since I'm sure this is in every one of their stock portfolios too. I mean, it really is sick that that's where our system of law is now, that rather than take the cases they need to, instead it's looked at more in through a political lens. That's what's best for the government, not what's best for the people or best for the Constitution.
Yep. So I want to tell you why I know they're gonna let that go. They're gonna prove the Rastafarian
dreadlock for people who have already lost their rights.
Yeah.
Because they're in prison.
Yeah. So just they got inside the federal prisons. They have what's called sweat lodges, depending with teepees. Swear to God, they have teepees in some of the federal prisons, which is called a sweat lodge, where they could go in and do whatever the shit they do with their little fire and stuff. And so if they're going to allow sweat lodges, which they do, they're going to let their dreadlocks. Watch. Remember this. Whenever this thing gets done, you're going to remember me saying it will be approved.
I mean, and don't get me wrong, I'm not diminishing any right at all.
Yeah.
Like, I'm not saying that they shouldn't have a religious right. But what I am saying is, why are they worried about dreadlocks for people who have lost their rights? Like,
yes.
That's the whole point of prison, is that you've lost your rights.
Right.
It's just, it's bizarre. And then meanwhile, the courts are denying all of us our rights.
Yeah,
you know?
It's ridiculous. It really is.
Yeah. Well, I mean, I think it's even worse than that. Like I said, they're really protecting their own interests, ignoring the people, ignoring the greater problem to protect themselves. That's what makes it so sick and disgusting.
So with all these things that you've been doing, right, and the money and time and stuff, and you mentioned General Flynn and Vandersteel, who I love, by the way,
Hands awesome.
and other people, right? Is anybody stepping up to say, hey, can I help you, Jason? Can I give you some money? Can I give you support? I mean, is there anything that's being done positive for other aspects or other individuals to help you with this fight?
Okay. So, and I obviously I don't have the whole list in front of me, but a big shout out goes to General Flynn for stepping right in, doing an amicus with his attorney, Bill Olson. Their amicus was brilliant. It was pure elegance. Ann Vandersteel, Maureen Steele with the American Made Foundation, they put in an amicus, and they had a whole bunch of signers, all sorts of people from, Lara Logan to Roger Stone.
I know Lara Logan too. She's awesome.
Yeah, they were all people that are concerned about our rights, and all of them, deserve credit for, at least putting their names on something, right? But doing the amicus, that's real work, and that's real money, and that's real time. Because guess what? They have to be printed too. But
could you explain for everyone, including myself, an amicus? Explain what
friend
that is.
Of the court.
So that is exactly it. It is a friend of the court that puts in a brief that either is in support or against a Supreme Court cert, or they can even abstain and just say, like, for example, we were just asking any Congress member. What a bunch of, like, oh God. Yeah. All we were asking them to do is, hey, all we're asking for here is a letter to the Supreme Court asking them to take the case. I don't need you to back me up. I don't need you to support me. Just do the job is all we're asking.
You couldn't get, none of them would do it.
Nobody would put their name on it. Nobody would lead it.
In terms of amicus is like a letter of endorsement of what you're doing from people on our that agree with what you're doing. And
right.
Yeah.
And I was
endorsement or unendorsement. Yeah.
Right. You don't need to endorse me or unendorse me. Just tell them to do the damn job. Right. Just do it so that at least we know. But a big and I want to take a moment for one individual by the name of David Morgan. David Morgan is I believe he's 87 years old. He is a humanitarian. He is absolutely an amazing gentleman. Sharp as a tack, right? But sharp, very sharp at his advanced maturity.
Sure.
He was a former Navy, fighter pilot, and he has made more effort and provided more support to what I'm doing than any other person out there outside of my lawyers.
Right.
And of course my family. My family has put through, I put them through hell in this whole situation, but they hang in there for me. But
yeah, they're in the battle with us. They have to
they have to sort of. It is just what it is, right? But David Morgan has, he's helped. I've helped him try to submit legislation. I rewrote the law so that it would never happen again, and Congress won't touch that because that would actually fix it. I mean, I see what's coming down the pike. They are going to screw this up so that we become a technocracy. That's what's going to happen, right? They don't want to fix 230 because they want to rewrite it, even though fixing it is simply applying it as it's written. It's already there. The law's fine. They just won't apply it right. Well, but I would say that David Morgan has put it up. Now, you do have the Social Media Freedom Foundation. It doesn't mean that other people can't contribute. There's a donation link on there. But one of the problems with being, I guess, an honest person, and I can't I can't ask people for money. Like it's a weird scenario because it's like, it's amazing when it comes in, it goes to real work on real stuff that affects real people. You know, I don't even take an income at all from social. I have literally never taken a dime personally from it. It has been entirely used on legal proceedings in order to fight it at the Supreme Court levels. That's all we've ever used money on. And yet, unfortunately, the problem is that, I mean, that's really what a politician is to go out there and say, hey, I need your support. I need your money and so forth. I'm going to do this, 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 and this. Oh, thank you for your money. Who are you again? That's Congress for you.
Yeah, it's your elected prostitute.
That is precisely how they function. It is. I mean, and it's, I thought about, maybe running for Congress, but realistically, then I got to go out, and I'm just not a good person. Like, I'll just go do it myself,
Yes.
Hand me the tools, and I'll just go take care of it myself. And
yeah, a real entrepreneur.
Yeah, it's a lot of burden on me. If you want to help, great. Socialmediafreedom.org. There's a donation link. It's real simple. Anything helps. It literally just goes into the bank account, and when we file certain things and there's hard costs involved, it pays for that. And everything we're fighting for is for everybody else's free speech and due process rights. We are entitled to be able to challenge big tech's decisions to restrain our individual liberties. That's the way the Constitution works. It's not the way the courts currently work, and we're trying to get it fixed, but I don't know. Supreme Court really let us down. Let us all down.
So obviously you're very hopeful in what you're doing, or you wouldn't be doing it, right? I mean, the next step in your battle or in your journey, what do you think? I mean, obviously you think you're gonna win, but I mean, what are your thoughts?
No, I think I'm gonna lose.
Are you? Okay.
Yeah, I honestly think that I'm gonna go in there, and unless I have some judge that is going to stand, like if I get the right judge, Facebook's done. Yeah. Like the whole system is going to come crashing down. But I mean, think of what that judge is going to have to do. That judge is going to have to stand his ground on one of the most important legal fights in history. It will decide whether or not the internet is controlled by the technocrats and government, or whether the people still control it.
Oh, yeah.
This is not just a case about me anymore. This is a case about the entire system. Right?
Yeah.
So we'll see. I mean, maybe the third. I don't have a lot of hope in the district side of things, but the Third Circuit has held their ground. The Third Circuit's a good circuit from where I'm going.
Where's that Third Circuit located? What state?
Like Pennsylvania area. Pennsylvania. I
really?
think it goes down. Yeah, to Maryland. It's that upper area, but the Third Circuit has gotten this. I mean, because we're going to be walking in there saying, "You guys got it right. This is the way it's actually supposed to work. You said it right. All we need you to do now is enjoin the defendants, United States government, from ever doing this again."
Yeah.
That's why I said it's a rare scenario where one court can enjoin another court, even if it's higher. Because the district court, now we did find out that the district courts cannot enjoin the United States president. Thank goodness, right? But they can enjoin their own judiciary, right? So it's a huge move, and I know Facebook's going to be pissed. I know I can already read what they're going to say.
Oh, I'm sure.
Oh, he's just angry that he lost.
Yeah.
No, I actually never even got a case. I never literally got a trial.
Yeah. Oh, and that's the core fundamental problem underlying all this is it's trillions of dollars and immeasurable power that's at stake right now. And unfortunately, a lot of these judges lack the courage to do the right thing and move the case forward. Now, hopefully, you do find someone that looks at it for what it is and advances the case to the Third Circuit, because this is something that we need resolution on, that I think there's a lot more at stake here than most people realize.
Yeah, Jay, when you have, over the years of your court hearings and so forth, has any of the big tech companies sat in there and watched, or they don't even bother? I'm just curious.
There's never been a hearing.
Yeah.
I've never seen the
your
inside of a court.
Yeah, I'm sorry.
I'm literally telling you, they did not adjudicate my case.
So,
they told me, F you at the door, you can't come in.
Yeah.
That's the whole reason I can bring the case over to a different jurisdiction, because it never happened.
Yeah. So
that is the very rare scenario where that works.
Yeah, when you're before the judge or ever, whatever. I mean, does any of the parties, that are interested, like Facebook or whatever, show up, or are they in there, watching?
I don't know. We'll have to see when I finally get a hearing.
They're probably not going to go.
Like that's what I'm trying to get to. Is I'm literally never even had a hearing, never talked to a judge, nothing. I was literally told, no, you can't come in. It's what I was saying is a jurisdictional bar, meaning the entire jurisdiction of California. I was barred from entering the court.
Mm-hmm.
I was not allowed to proceed because they said it's an immunity from suit. And the funny thing is, and this is the irony of what Facebook what the court determined. They said that I failed to allege enough facts to supersede immunity. Now think about that. I wasn't allowed to develop my facts or get discovery because it was immunity, but I failed to allege enough facts to supersede sovereignty. Think about that for a moment. You can't allege enough facts to get past immunity. Yeah. It's not possible.
Yeah.
So basically what they're saying is that they applied what was, like I said, an affirmative defense. They changed it into an immunity from all suit. You are not allowed to sue big tech. And that's not the way it functions legally. It's not constitutional. And that's what we've been trying to say all along is that the fact that they're preventing anybody from getting into court is the reason why the internet is busted. There's no accountability whatsoever for big tech. And that is by design, because the United States government has been in bed with big tech, protecting them unconstitutionally from us, from all of the people that are the users who are getting stomped on. Why? Because then they're doing big tech's bidding. It's not a real complex scheme, right?
Yeah.
It's a big racket. We'll protect you. You do what we want. Sad, right?
Yeah, it really is. It's unbelievable, but also kind of anymore. It's what I expect out of most of these people. I'm glad to see that some of that is starting to change. Glad to see that the DOJ may be making some moves here. But, this is probably a much bigger problem that affects more people than any of us realize. And this is the kind of change that we really need to empower individuals again and take control over something that is ours. It's our nation, it's our country, and it's our internet. It's time to assert our rights over it.
Yeah. So what does Dan Bongino think about this now that he's in the DOJ with his Rumble and interests?
Dan Bongino doesn't like me all that much.
Yeah.
I don't care. I don't like him that much either. So it's all good. You can't like everybody in the system. But at the same time, I hope that he does a good job and so forth. I mean, he doesn't have to like me and I don't have to like him, but respectfully, I would say that, he's in the FBI, right. He's in the FBI.
Yeah.
Just do the job right. And that's what I would say of anybody is that, and I think that's more
I was
just
conservative
thing is,
about, maybe influences because of his, Rumble and interests of Rumble. And, you mentioned the DOJ and falling on the sword.
Why do you think he doesn't like me?
Yeah.
Because of those influences. I called them out. Like Dan Bongino, you know what?
Yeah, we'll save.
I do not want to get into.
Yeah.
I respect the man. I respect what he's doing at the FBI. I hope he does well. I hope he doesn't have alternate interests beyond that. If he does, he does. If he doesn't, he doesn't. It's not really a my way anymore. I've lost respect for the courts. I mean, total respect for a lot of these courts.
Yeah.
But
Well,
there are others that are, for sure, patriots that aren't trying to capitalize on this. I mean, but I have my questions about all of them. I mean, everybody that, and I'm not going to name names, but you see a lot of people that succeed on the conservative side, right?
Mm-hmm.
Why? Why do they succeed? Right?
Yeah.
The best way to play this is controlled opposition. And
Oh my God.
and that's the reality of what I think that I'm learning here is that the courts are they're controlled. There's no real way to get through it. And unless I get some judge that just cares about the Constitution, that has the laurels to stand on, and unless I get that, I mean, that's why you said, you have hope you're going to win. No, I think it was a shame because the people that helped with the amicus briefs, a lot of them were sad because the Supreme Court didn't take it up, and they were shocked. I'm like, how could they not?
Yeah.
And of course, I had about a half an hour of being pissed off, and then it was like, no, because I knew they wouldn't. I knew they would. I could literally give them the grace of God in a document, and they'd be like, nope, we're not gonna read it, because I think that the clerks are actually the ones intercepting it. I think
I'm sure that has a big part of it, and they've been given their marching orders.
Yeah. So I think we're at the end here, right, Mike? Yeah, based on our little late start. And, And just want to thank you very much. I think we're obviously going to be in touch with you, Jason, and do whatever we can to make sure we get your voice out there, because other podcasters and Mike, I'm sure he's going to have you on some of the other shows, that you just got to keep it out there and let people hear your voice and hear what you're doing.
Yeah, well, if there's enough attorneys out there that hear that there's a solution to this, keep bringing cases. And the biggest suggestion I would have for anybody else that is thinking about suing big tech, suing your own state. Point to my case, right? Because they're going to do a motion to transfer. They're going to try and get your forum selection. They're going to try and push it out to California. And you can point to my case and say, well, yeah, if it goes to California, it's going to be applied as an immunity from suit, when they themselves have said it's not an immunity from suit, meaning there's no consistency in law in California.
Yeah.
Arguably, it's in the public interest to keep it where it's at. And a lot of people miss that that's the problem, even with like HB 20 out of Texas. If the forum selection drops them back in California immediately, HB 20 is useless, because all they have to do is put in the terms of service, and all of a sudden the case goes back to the one court, that court set that's already biased and controlled.
Yes.
There's your problem. You're sending it back to the same corrupt court. So anyhow, but now I thank you, gentlemen, for having me on.
Thank
you.
you.
Yeah.
I hope I gave you some interesting stuff to think about. I hope
very good.
your audience actually listens. I try to simplify this. It's this is really fixable, but we'll have to see if the government's actually going to let us do it.
Yeah. No, it was very helpful. It was.
Yeah, I agree, and I do think this is something that will really resonate with our audience, that this is a problem a lot of them have encountered too. Anybody that's posted a meme on their Facebook account then got put in timeout for a week, that may not have impacted you financially. It might have been just enough to piss you off, but it's another tentacle on the same monster.
Yeah, I could come up with so many examples. The Facebook decided they were going to hit me again. I think about 2 to 3 weeks ago, which of course gives me new harms to come after them again. So I mean, I've got brand new stuff. Do you know that the posts were actually not posted by me? They were posted on a page that I own and control from 11 years ago.
Wow. Are you on Facebook?
Yeah, I'm still there, barely, but yeah.
I got
basically every time I start getting close to courts, like as soon as I'm about to go back into courts, bam, I start getting hit with, and they don't even have anything that they can even use. So now they're going back 11 years, a decade, to find something against me.
I had a bunch of Democrats take me down in a little fake Republican Democrats that
undocumented Democrats.
Yeah, mass reported me. I'll be back. I'll find a way to be back, Jason.
Yep, that's the only thing you can do is we'll just keep fighting it and keep fighting it, keep fighting it. I don't know. Hopefully, Trump can lead the way on this. That's the only thing you can say is just, you hope the guy's got it under control. I do see promising stuff happening on the DOJ. let's see how it all plays out. You know, everybody's so quick to judge, and it's like, this doesn't get fixed immediately. It's such a slow process. But a lot of people, like, you know, you guys, myself, we're not letting this go. Like, I know that I'm going to be at this probably for the rest of my life.
Yeah,
you know?
This is a fight worth having, and
sure.
It's obviously had a greater impact on you. But I get pissed off every single time we get one of these strikes, get deplatformed on something, and then they won't tell us what it is we did. It's just infuriating, and that's small potatoes compared to what you're dealing with. Yeah, to our audience, please like, share, and subscribe. Help us to grow so we can bring more people the news, the mainstream media.